The right to housing in Canada, Victoria v. Adams. In Canada, the right to housing is not directly protected under the law. However, in one court case, the Canadian Charter of Rights and Freedoms, one of Canada's most important laws, was shown to give some protection to people facing homelessness. This case is known as Victoria v. Adams. In Victoria, British Columbia, there was a big problem with homelessness. There was not enough affordable or accessible housing, leaving many people without a home. Even though there were homeless shelters in the city, there were not enough, leaving many homeless people without a safe place to sleep. This forced a lot of homeless people to set up tents in parks and other public spaces. These were known as tent cities. The city of Victoria did not like these tent cities, so they introduced a rule, known as a bylaw, that overnight shelters, like the tents in the tent cities, were not allowed. This rule would result in these tent cities being taken down, leaving the people who already did not have homes without any shelter or safe place to stay. Even though this bylaw applied to everyone in the city, the people who were most affected were the homeless people living in these tent cities. Many people thought that this bylaw was not fair, and some of them decided that they needed to do something to change it. A group of activists took the city to court, challenging this bylaw and saying that it was unfair and that it violated the charter rights of the people living in these tent cities. Under Section 7 of the Charter, everyone has a right to life, liberty, and security of the person. This means that people have a right to live, a right to be free, and a right to physical safety, and that governments cannot break these rights without a good reason and by following a fair procedure. The activists argued that because this bylaw would force people to leave the tent cities and have no safe shelter or home, this violated the Charter Section 7 rights of the homeless people. This would violate Section 7 because without shelter, homeless people were at risk getting sick and even dying from exposure to the environment. This would violate their right to physical safety and life. The court agreed with the activists. The court said that being able to have shelter and protect yourself from weather and the environment is a very important part of the right to life, liberty, and security of the person. As the city did not have enough homeless shelters to provide safe shelter for the people living in the tent cities, this bylaw, by not allowing homeless people to create temporary shelter, like the ones in the tent cities, put homeless people at risk of health problems and death. The court said that the bylaw was unfair, and this led to the bylaw being removed. This case is a very important case in Canadian law, especially for protection of homeless people. It reminds us that being able to have a safe shelter from the weather and the environment is very important in respecting everyone's Section 7 rights under the Charter.